Apologies, we were having technical difficulties with the stream. Apologies, we were having technical difficulties with the stream. If you are on LinkedIn, apologies, we were having technical difficulties. If you're on LinkedIn, please turn to YouTube, Facebook, or Twitter. There is something going on with LinkedIn that, for whatever reason, wouldn't allow us to stream the event. Okay. So we'll begin now. Again, sorry for the inconvenience. So my name is Yuri Nemetz. I'm an attorney and a managing member at Nemetz PLC, a law firm based in Washington, D.C. This is the fifth of the webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the International Wanted List. My co-panelists today are Michelle Asland of Asland Law in Miami, and Jago Russell of Boutique LLP, a law firm based in London. From 2008 to 2021, Jago served as the CEO of Fair Trials, an advocacy organization that played a major role in Interpol's reforms of 2016 and 2017. The most important, in my opinion, reforms to Interpol's redress mechanism. And this is exactly what we're going to talk about today. We're going to talk about what led to those reforms, what proposals Interpol received, which of those proposals it implemented, and which of those proposals it has not implemented, and what further reforms need to be carried out to bring the redress mechanism closer to the modern democratic due process standards. And we will also talk about how those reforms have affected the work of practitioners like us, those who represent the victims of Interpol abuse. So I'll hand it over to Jago now.
Thanks, Yuri. It's great to join the discussion today. Firstly, I think I should probably just clarify. So I was at Fair Trials for a very long period of time and actively involved in Fair Trials work on Interpol reform with some brilliant colleagues, Bruno Min, Alex Tinsley, and many others who will be familiar to some people on the call perhaps. But I'm not now speaking on behalf of Fair Trials. I'm no longer employed by the organisation. I have a very different perspective on Interpol, and that is from the perspective of a private practitioner who is doing a lot of work on Interpol. So it's really interesting having seen the same organisation from different perspectives, from the perspective of an NGO trying to change it, and from the perspective of a defence lawyer trying to prevent Interpol's work doing damage to its clients' reputations, lives, etc. I thought it might be quite useful to just give a kind of a potted history of the reforms and the reform process. And I think it's potentially interesting because it gives a bit of an insight into Interpol, and Interpol is a very secretive organisation generally, as you might expect for a policing organisation. So it gives a bit of an insight into that. It kind of gives some background as to why the changes were made, the things that were driving the changes. And I think it's also potentially relevant because, as I'm sure we'll come on to, a lot of the changes that need to be made to Interpol haven't yet been made. And perhaps there are some lessons to be learned from the kind of previous reform process as to how we might succeed in getting some further changes made to make Interpol even kind of more effective for policing, but also much fairer for the individuals who are affected by its red notices and diffusions. I have a particular perspective on what the problems were. So I can say a bit about the things that made Fair Trials as an organisation decide to take on the challenge of trying to persuade Interpol to reform how it operates. But I think it would also be super interesting to hear from you, Michelle, in terms of, and you, Yuri, in terms of your perspective on what things were like as practitioners dealing with Interpol before the reforms. I mean, in broad outline, what we were getting at Fair Trials is quite a lot of people who were stuck in this awful situation where they, often paid lots of money and had huge legal battles to defeat extradition requests. And then at the end of the extradition proceedings, the extradition lawyers have to say to them, but, by the way, you're probably never going to be able to travel safely again because there's this thing called Interpol and it's probably circulated your name all over the world. And so, there were kind of issues that people were coming to us with as an organization, and practitioners were, about this kind of residual effect of Interpol after you've won an extradition battle. Likewise with people that had asylum, people that had been given asylum by countries because they'd faced political prosecution, then discovering that, as well as the prosecution domestically, they were subject to Interpol red notices, and then some really shocking cases that linked to that came to fair trials. So Benny Wender, who was kind of publicly named and shamed on a public red notice on Interpol's website for his activism for the people of West Papua, that Indonesia, the government of Indonesia, really didn't like, and so they basically got a public red notice against Benny with the kind of symbol of the West Papua movement behind it. So both criminalizing internationally Benny, but also his movement. So that was kind of where it came from. From us, we were seeing these incredible people who were being pursued across the globe through Interpol. And it didn't seem right to us that an organization was having such an enormous human rights impact, but we couldn't quite figure out how to solve those problems for the people that were affected. But as I said, I thought it'd be interesting to hear as well from the two of you in terms of, as a practitioner before the reforms, what it was like.
Well, from my perspective, can you hear me okay? Yeah?
Yeah.
Okay. From my perspective, I remember when I first started doing this work, and this was about 12 years ago, it was very different. It was more frustrating because there was not as much accountability as there is now. So for example, if somebody had a red notice and was seeking its removal, there was no timeline within which Interpol had to, or the CCF had to make a decision, the Commission for the Control of Interpol's Files. There truly was no accountability, even when we requested accountability. So it was very difficult for people to have any sort of plan or closure when they were suffering in the way that you just described. Another thing was that the website of Interpol was not as user-friendly as it is now. It didn't contain nearly the information that it contains now. And it still is a lot to navigate if you're unfamiliar with it, but at least now there are some answers and there's some guidance there on what to do. I remember very specifically the first time I talked to Fair Trials about this. And I went to Fair Trials offices in the UK, and it was a small office with a lot of really good-hearted people. And went to Fair. Oh, I'm getting a reverberation there, sorry. And I remember being astounded at what Fair Trials ended up doing with a small group of people, and I know not a lot of funding, but just such brilliant work. So, Fair Trials went, and you'll correct me if I'm wrong, Jago, in my perspective, it went from being an organization that was investigating what was going on with Interpol and what were the problems with it, and kind of, thinking, how do we address this? And taking different approaches, because that's what you do when you're figuring something out, to being the leading advocacy organization for Interpol reform and being very effective in doing so. So from my perspective, before reforms began and before a real call for reform was heated, it was a frustrating practice. It was unpredictable, and the results that the answers that we got, even when we won, were not particularly instructive.
Thanks, Michelle. I remember your visit to Fair Trials officers very well. And I think you brought us a very nice box of chocolates, for which thank you once again. Yep. You're right. Like we had to start by figuring out what was going wrong and why it was going wrong. And so I think what we basically came down to was the conclusion that under the leadership of Ron Noble, who was the former Secretary General, Interpol had become understandably obsessed with trying to speed things up and to get more information circulated more quickly around the world. So it created new database kind of new systems where police could directly upload stuff onto its system. So draft red notices could be put immediately onto Interpol's database with no involvement by Interpol. And I think it's kind of perhaps built around this maybe apocryphal story that after 9/11, Ron Noble was horrified that after 9/11, not a single person thought to contact Interpol to ask for its help or assistance. And so really Ron Noble tried to set about making this an organization that circulated tons of information really quickly. And the problem is that in the process of doing that, the processes for kind of making sure that the data that was circulated was useful, was accurate, was not abusive, they all kind of went out the window because everything was being done as quickly as possible. And so the numbers of red notices increased hugely as a result of that, from just over 1,000 in 2002 to over 8,000 by 2012. So, massive change under Noble. So we kind of knew what the problem was, and then we needed to figure out who could fix it. And that's one of the interesting things with Interpol, is because it's this kind of quasi-international organization, you can't go to the normal kind of, lobby parliament or advocacy in parliament or through the courts, through litigation to get it to change. So we really came down to the idea that the only people that could change Interpol really were Interpol itself and the member countries of Interpol, by telling Interpol that it needed to implement changes. So that's really where we kind of got focused. And the things that we identified as the drivers for reform, the things that would make Interpol want to introduce changes to create more safeguards against abuse and better redress mechanisms. So the first one was the fear about immunity. So there's been this growing recognition that international organizations cannot claim immunity where their actions breach people's human rights. And some very clever lawyers were starting to take challenges to say, look, you Interpol are abusing my client's human rights and you're not allowed to do that. And they were trying to kind of to pierce Interpol's immunity, and that had massive implications for Interpol if that succeeded. So financial in terms of the damages awards that might be granted, but also operational in terms of, an international policing organization having domestic courts scrutinizing how it acted in international police cooperation matters. So that was a big driver, is trying to make sure that Interpol had sufficient internal safeguards so that it could continue to maintain its position of immunity. Credibility was the second one. So Interpol loved this kind of James Bond image, we're the global good guys. And, it was not good for Interpol that there were numerous stories that were emerging in the press of human rights activists and journalists and political opponents who were being chased down by Interpol. And its member countries were getting really embarrassed by the fact that they were picking people up on red notices that they shouldn't be arresting. And so its credibility was undermined. And that then led into kind of international pressure from the UN and from the Parliamentary Assembly of the Council of Europe. And so those are all the things that were kind of like driving Interpol to think about changing. And I think for me, at least, and I may be kind of over positive or over optimistic, but it really felt to me like the new Secretary General, Jürgen Stock, people were the things that kind of really drove change. And Fair Trials had produced its report on Interpol reform just before he came into post in 2014. And I know that it was on his desk when he started the job. And I know that he realized very quickly that reforming the organization was a real priority. So, for all the reasons I've described. And so he really set about trying to kind of drive the reform process. So, that's kind of the background. I don't know where you want to go now, Yuri, or what you think it'd be useful.
Yeah, can you talk about like what proposals were made to Interpol, and which of them, it implemented, which of them it did not?
Yeah. Honestly, a lot of the proposals that we put forward were implemented, or the rules were changed to accommodate them. I think implementation's a slightly different thing. So effectively, we asked for two broad bunches of things. We asked for better review mechanisms up front. So Interpol doing a better job of reviewing red notices and diffusions before the damage was done, before they'd been circulated around the world. And so Interpol fixed that, partly in parts. So they stopped this draft red notice thing. They stopped the ability for red notices to be circulated in draft and put on Interpol's database in draft before anyone had a chance to look at them. And it created a notices and diffusions task force, effectively a beefed up internal unit within Interpol that reviews all red notice requests and all diffusion requests. It's a different form of wanted person alert before that information, before the diffusion is put on the Interpol database. So that was one set of reforms we were asking for. So better kind of review before publication. And then the second area we really focused on at Fair Trials was the need for review mechanisms. So however good the initial filtering is, it's never going to pick everything up. And so the points that Michelle, you were making earlier on, it was really clear to Fair Trials that you needed to create a really effective mechanism that people could go to if they found or they were worried that they might be the subject of an Interpol red notice. So a lot of the reforms that were proposed related to improving the CCF as an oversight mechanism, making it more independent of the General Secretariat, creating a dedicated unit within the CCF, part of the CCF, to review complaints or applications by individuals, tighter timeframes so that you had a better idea of how quickly you'd get a response if you made a complaint. More transparency, that was another thing, is we were arguing there should be a presumption that the person affected by the red notice should be given access to information so that they can challenge it. And so, we were asking for a presumption of transparency, and I know that's not working brilliantly well in many cases, or at least in my experience. Often you don't get much, even now when you ask. So there were those changes, and then there were just a couple of other things I'd like to highlight. So one is refugees. We've been arguing at Fair Trials for a long time that it's completely inappropriate that when a person is protected from refoulement to the country that's persecuting them, nonetheless, that country has been able to obtain a red notice against the refugee. And so we said that Interpol needed to introduce specific protections for refugees. And I'm pleased to say that they have introduced a policy. They've not yet published it, as far as I'm aware, on their own website, but they do have a policy that they will remove red notices or diffusions against refugees. And in my experience, that's had a massive impact. If you have a client in that situation, you can now get a really quick decision by Interpol to delete the red notice. So, there were a lot of reforms that we requested, and I reckon we got about, at least on paper, about 70% of them or something. There's a fair bit that we didn't get. And I'm really happy to discuss that with you guys if that would be useful. But there was a lot. There were a lot more changes were implemented, at least on paper, than I have to say I'd expected as the chief exec of Fair Trials when we decided to start what felt like a bit of a David and Goliath kind of battle.
With regard to access to the information, I remember it was an interesting move. I'm not sure what it was caused by, but when the statute of the new statute of the Commission was adopted as part of those reforms, Interpol moved from this presumption that if an individual had what they considered proof that she or he knew that there was information about them in a database, CCF was, at least on paper, it was supposed to release this information without obtaining the government's consent. That went away. So that was sort of like an interesting step back. And it's still the rule now since 2017 is that it doesn't really matter if you know, if you don't know that you're in a database, they will still, in any case, they will request the government's consent. So I thought that was sort of like a step back from transparency or from access to the information. But in terms of because we're already there, in terms of the reforms that Fair Trials proposed and Interpol did not implement, can you talk about those?
Yeah, there were. I mean, again, so there's quite a few. The big one really related to diffusions, I think, and for me, that's still the biggest issue. Is the fact that you can, if you're beefing up your upfront review process, so that all red notices are reviewed and all diffusions are reviewed before being uploaded to the database. Countries that want to abuse the system will think, how on earth am I going to get around this review? Because sure as hell, if anybody at Interpol looks at this request, they're going to say no to it. And what Interpol has done is left open this kind of gaping hole in their review process, which allows member countries to circulate information all over the world through Interpol systems in the form of diffusions without anybody at Interpol looking at it. So, a diffusion can either be just sent out through Interpol, or it can be sent out and uploaded onto the Interpol database. If it's uploaded onto the Interpol database, at some point Interpol will look at it and review it and decide whether to put it on the database. But if the country doesn't ask for it to go on the database, it's never reviewed by Interpol. And so there's this whole range of these wanted person alerts that are being circulated through Interpol that no one's looking at, and that for me feels like a kind of a real failure and a really kind of vulnerable point for Interpol in terms of its ability to claim that it has proper processes that justify its immunity, that protects people's personal information and human rights, and that would probably be the biggie. I mean, there are other things, but I'll stop at the biggie because I'm sure you guys have thoughts about things as well that should have been changed, that we've asked to change that haven't been.
Yeah, well, and diffusions seem like, because again, as I said, there are many more diffusions than red notices. Obviously a convenient mechanism for countries that seek to abuse the system. But I agree. I don't think anything has been done. I think the only example when something meaningful, in my opinion, has been done by Interpol in terms of diffusions is that press release that Interpol issued following the invasion, following the events in Ukraine, where they said that, okay, we're going to be checking. That it said that Russia has to submit all notices, with the red notices or diffusions, all government requests through the General Secretariat. I don't know if in practice it's actually being done, if Interpol has the ability to monitor whatever diffusions Russia is trying to submit, if it does, without resorting to the General Secretariat, to that screening first. But that's the only thing that I know of that Interpol has done in terms of minimize whatever abuse that happens because of government's use of diffusions. And but I also want to say, I sort of want to give credit to CCF, because one thing that was not done as part of this reforms of 2016 and 2017, actually two things. Going back to access to the information, CCF sort of stepped in, and because it has at least what we call as its own case law, it said that, well, okay, now the governments have this absolute right to refuse access to deny access to the information in the database. But then the commission said, well, it's actually not an absolute right, because if the government doesn't act in good faith, if it doesn't provide a justified explanation why it wouldn't let the individual access the information, we might block it. So that was one of the decisions that actually there's an excerpt published on the CCF website on that. I thought that was a good step forward. And then the other thing that CCF did that the General Assembly did not do, it sort of expanded this, because there is no right to appeal. At least there is no appeal as of right within CCF, and you can only submit the request for reconsideration, which means you have to prove that there are new circumstances that you didn't know about at the time when the commission reviewed the original case. But then CCF ruled in one of the cases that, and issued a decision excerpt that As a matter of fact, you can still submit a request for reconsideration. They obviously don't call it an appeal, but as long as you can prove that the law was applied incorrectly, or the facts were interpreted incorrectly, and so forth, it's sort of like quasi appeal. They sort of went beyond what actually the statute says, which I was really surprised by. But they did at least partially fill in. There is still no right to appeal. No appeal is a right. There is no right to a hearing, and there is no right to technically to examine evidence that the government produced against you without the government's consent. But again, the commission sort of like tries to manage that, to sort of like keep the balance. But in terms of like further reforms, do you think that that is actually going to be done at some point or not? Because the several most recent General Assemblies following the reforms, they didn't really give any indication, at least not in my opinion, that they're actually eager to do something to do more to bring the mechanism closer to due process at all. I mean, all the decisions that they've made, they were going, at least it was sort of like a sign that they were going in the opposite direction. The new president of Interpol, and then as you mentioned again with transparency, it's not only the refugee policy that we all know about that was adopted by the executive committee back in 2014, and it's still, as you rightfully said, it's still not on the Interpol website. Who knows why? I actually have a decision in one of the cases that I handled, and CCF responded that we're deleting the information because your client is an asylum seeker, and then they said based on, and then the name of the policy was redacted. So plus of course CCF's annual reforms. I think the last couple of years they just completely stopped releasing any information about even the number of requests, individual requests they received against each and every country. So in this context, do you think that we can expect any further reforms anytime soon? I mean, I'm very pessimistic, I have to admit, but maybe you have a different take on that.
Who are you asking?
Both.
Well, I'll give my opinion. I don't think we should expect any reforms without a hard press like what we saw from fair trials. It was ongoing, it was deliberate, it was consistent. And without that, I do not think the reforms would have happened. We've had in the US side a lot of internal conversations and congressional action and all of that about what we should do regarding Interpol abuses. But in terms of active work for reform directly with Interpol and Interpol's representatives, that's what I think it would take to get more reforms. And if we look at the broader world of international organizations and how quickly or slowly they change, we know that we're probably still in the phase of we should be grateful for what happened recently.
Right. At least, and that's what they want us to think and say.
And I will also say that in terms of the relationship between the CCF, the Commission for the Control of Interpol's Files, which is the body you guys have been talking about, we've been addressing, that people go to for relief, and the larger body of Interpol, we have to remember, at least from my perspective, my observation, there's always kind of a relationship that's not, where their goals are not completely consistent. Interpol is a political organization. The votes are made with knowledge when they're voting at the General Assembly. Other countries they know what the other countries are doing, that sort of thing. The CCF is more insulated and has the mission specifically to look out for human rights. The body at large of Interpol is a law enforcement assistance organization. I don't think we should expect that the larger organization is going to be particularly focused on human rights unless they're getting called to task for violations, and in terms of like what the reforms have been in what we feel, it's difficult to say sometimes. We can see that we're getting better decisions, more thorough decisions, certainly more timely decisions from the CCF. But we also only know what we know because they don't publish all of their decisions. And we don't know, unless you know anecdotally, what has gotten through to become a red notice. We don't know how many red notices have been stopped, unless, of course, you have, again, anecdotally done that you've got a preemptive request and you've received feedback that was successful. So it's hard to measure exactly how successful some of the reforms are, and they may be stopping thousands and thousands of pieces of data from going through, and we're not necessarily going to know it. As we talked about before we came on, I have another engagement. I'm going to have to leave in just.
Yes, of course. Yeah, we will have to let Michelle go in several minutes. I just wanted to our audience, thank you everybody who switched to YouTube from LinkedIn. There is an issue going on with LinkedIn. Apparently, somehow it's not letting us stream, and it's not on the on part of those who we actually use to stream this at the same time on several social media accounts. But Michelle, whenever you need, please feel free to jump. Please post your. I just let everybody know. So on YouTube or on Twitter, Facebook, wherever you're watching this, feel free to post questions. We'll try to answer. We'll try to answer them. In terms of we turn to Michelle mentioned Interpol acting preemptively. I guess that's what you were talking about when you were talking about how many government requests they're stopping. In terms of the numbers, I mean, we had this publication at the end of last year when the Notice and Diffusion Task Force, which is sort of like the other part of the redress mechanism that is not CCF. It's literally under the General Secretariat's purview. And they did publish the numbers, how many red notices and what they call wanted diffusions they've deleted. But the numbers are like everything with Interpol's transparency. I mean, they don't really tell, at least me, a lot, because they sort of it's pretty vague. In other words, for example, they don't say how many of this government requests they stopped or deleted.
That's the thing.
Because and especially because of the information that they were able to obtain and make the decision before the individual got detained or after, because there have been cases in which the case would be widely publicized in the media, and then the General Secretariat, because the person had already been detained, and then the General Secretariat would come up with a statement, something like, based on this new information, we have deleted this government request. The problem is that, of course, it's too late because the individual has already been detained. Yeah. And this is not in these numbers at all. Plus, of course, and that was following the reforms, the Commission in one of its reports said that it had dealt with cases in which the same individuals whose red notices with wanted diffusions it deleted, it found non-compliant with Interpol's rules. The same individuals ended up in Interpol's database again, as if it was a red notice was deleted, then the same government was able to put the same person into the database as a diffusion, and then after the diffusion got deleted, they abused the stolen and lost travel documents database.
Right, and then another thing that relates to that happens constantly, and just happened yesterday to a client of mine, is that Interpol's not able to control what its member countries do with their domestic databases. So the member countries are supposed to update their databases when a notice has been deleted or a diffusion has been deleted, or they've got a period of time within which to do it. I have a client who yesterday had a notice removed over 4 years ago and was stopped and prevented from entering a country because that country had not updated its databases despite multiple efforts by Interpol to remind them. So there's a lack of control that Interpol has that allows its member countries to not abide by their obligations, which include updating their domestic databases. And that continues to be a problem, even when Interpol has done the right thing. And that is going to come down to eventually accountability. And if we see a lawsuit, then I think we'll see some progress. But barring that, I don't think we're going to see progress. And I apologize, but I have to jump off now.
Yeah, of course.
Thank you so much for having me.
Sure. So it's going to be Jago and me now. I think that from what we just discussed, basically there was some really important reforms carried out, obviously, but then, and they were important. Like the commission is now stacked with lawyers. Before that, I believe there was just, if I'm not mistaken, at least at some point in time, there was just one lawyer, right? And then there was a data protection specialist, and then something international police cooperation specialist. So like technical people, I don't know if they had any legal background, but it seemed to me a little bit strange that somebody with that qualification was supposed to adjudicate individual rates. It didn't make a lot of sense to me. They stack with lawyers now, it's true, and there are deadlines now within which the commission is supposed to review a case. They're supposed to issue reasoned decisions, but nevertheless, and these are technically basic requirements that any due process, we expect from any, I guess, more or less civilized system now. But then at the same time, again, in addition to what we just mentioned already, to appeal, to a hearing, to examine evidence without the government's consent, we still don't know if there is an effective mechanism that fixes that problem that CCF, again, by its own admission, dealt with when the enforcement of its own decisions, even though they're mandatory for the General Secretariat, were not really enforced. The annual report in which the Commission admits to that problem says that the Commission dealt with those cases. So in other words, it fixed that problem, but specifically to the cases, of course, it doesn't mention them in the report, but specifically to those cases that it had dealt with. What we don't know is whether the General Secretariat actually introduced a mechanism that would filter incoming government requests and match them against that. That's, in my opinion, how that would be implemented. I think it's a pretty simple thing to do. Match them with a list of names who the Commission has already declared to be victims of Interpol abuse, and then stop them before they get published. Of course, that's red notices. Probably that's when it's possible. With diffusions, I mean, I think they could still do that, but we don't know if this is the case. There has been no official explanation from Interpol on that. I know, Archag, if you agree with me or not, but that's been my experience.
Yeah, and I think just going back to your question about whether we're going to get any more reform, I think that's a really interesting and a difficult one. So for me, one of the problems with the reforms is an implementation problem. So, the kind of process that you're talking about there, Yuri, it involves people. It involves having sufficient people to be able to carry out the checks. And I suspect that Interpol is struggling to get from its member countries sufficient seconded lawyers to do the job of the kind of checks that are necessary. And so I think, like having enough people to do the checks is important. So my hope would be that if, as Michelle said, there continues to be negative publicity and political comment about misuses of Interpol systems, that one of the things that can be done is actually put the manpower behind the processes that have been introduced. And I think the same probably applies for the CCF. It's getting a huge number of requests now for data to be deleted or amended, but it still has, I think, really minimal resources. So there's a real kind of implementation challenge and the need for resources to make the changes work properly. And then in big picture terms, we've seen the massive shift in kind of global political power very much in the context of these high profile, controversial elections to the president of Interpol. So we've seen that in terms of Russia's attempt to get a Russian president and the Chinese president. We've seen that happen at the presidential level, But the role of president at Interpol is actually not the powerful role in terms of day-to-day operations and what the organization does. And so for me, the big question is who's going to replace Jürgen Stock. So my understanding is that his second term and his last term comes to an end next year. So, who's going to step into that position? Is it going to be somebody that, as Jürgen Stock seemed to do, recognised that reforms needed to be made and was willing to fight the really difficult battle with the police forces that were effectively its members, Interpol's members, to persuade them to make changes? Or would it actually be somebody that is more of the Ron Noble style? The more we circulate, the more quickly, the better, and that will kind of backtrack on the reforms that have been made. So I think there is a real risk that a new Secretary General could backtrack on that. For me, the kind of hope for change comes, maybe it's because I'm just wearing a different hat now, but I do think litigation could do quite a lot. I do think Interpol is very, very vulnerable, and Interpol's immunity is vulnerable, particularly in respect of diffusions and the failure to have any process to ensure that Interpol data processing, which results in these wanted person alerts being circulated all over the world with massive implications without any effective review. I think there's a real potential for litigation to succeed to challenge Interpol on that. And I think we're also going to start seeing, and I think we are starting to see, including in the US, court decisions which basically say you shouldn't trust Interpol alerts. It's not a valid basis to refuse asylum. It's not a valid basis to detain someone under immigration powers. It's not a valid basis to refuse a visa. It's not a valid basis to arrest somebody for the purpose of extradition. So hopefully, if we can, the campaigning organizations continue with the advocacy and with the lobbying type work. But as lawyers, I think there's a lot we can do in terms of litigation and really, really challenging again this idea that Interpol has done enough to justify maintaining its immunity from legal proceedings and trying to continue challenging countries placing any kind of weight or trust on information that's obtained via Interpol, because I don't think it is that trustworthy, and I don't think it is that reliable, and I don't think people's immigration decisions should be affected by the fact that there's some notice or diffusion that's been sent out by Interpol, because I don't think it means anything. I don't think they have, weight to them.
No, I agree. All valid points. I mean, I think this is also an interesting approach that, for example, the courts here in the United States have taken, because it's true there have been several rulings by even federal courts in which, not just immigration courts, but even federal courts in which our Article 3 courts have said that, well, as you said, red notices are not reliable, by themselves, because there's literally, courts have said that, there is no reliable pre-screening that would prove that there is any legitimacy to that prosecution behind the red notice or diffusion. But at the same time, we have cases like not that long ago, there was a decision, that judgment. Well, it wasn't really a judgment because the case didn't even get to trial. El Omari, in which the court said versus Interpol, El Omari against versus Interpol, in which the court said, well, because of the International Organizations Immunities Act, you can't sue Interpol because it has immunity. So basically, here in the States, at least so far, it seems like there is no path to actually bring Interpol before a court of law and on the lawsuit, based on egregious violations of due process sometimes. So it's true in terms of, and I agree. I mean, it's interesting also because CCF was created to, I guess the real intent of the organization was not as much to comply with human rights requirements, but to protect Interpol from potential lawsuits because it wasn't complying with human rights instruments. and it's at a very basic level. And nevertheless, there seems like no way to actually get through that. So far, the only body that we can appeal to against Interpol is Interpol itself. And again, even there is no right. There is no appeal as of right. In terms of the resources, I also agree with you, because the Commission has tried to draw the General Assembly's attention to the fact that it does not have enough resources even for the work that it's doing now, and of course much less to create, for example, an appeals chamber, even if it was described in a statute, which it is not. I don't know. That's why as much as I want to be optimistic, it seems pretty pessimistic to me so far in terms of whatever further reforms. So I think that we have probably covered a lot today. Again, I apologize for the technical problems that we had with LinkedIn. We never had them before. We'll try to figure that out. If not, then we can always just make YouTube as our main platform for this webinars. And Jag, unless you want to add something else, I thank you for participating. I hope we'll do it again soon. And to our audience, if you have questions, again, feel free to pause them under the video, and then we will on any platform, and we'll try to answer them during our future webinars. Thank you again, Jago. I greatly appreciate it, and thank you for everybody who attended today.
Thanks. Really good to speak. Bye.
Likewise.